So the other day I was reading through the news, and I happened to see this article from The Atlantic by former Supreme Court Justice John Paul Stevens, who's essentially arguing that District of Columbia versus Heller, which recognized an individual right to keep and bear arms under the Constitution, was not only wrongly decided, but was the worst decision of his tenure on the court. Now, given some of the cases that have come up during his tenure on the court, Bush versus Gore, Kelo versus New London, all sorts of things, I think it's quite obvious, just based on the evidence, that this is not the worst decision that he's ever presided over. And some of the things he brings up in this article are just factually inaccurate. So in the interest of fair critique, I would like to go over a few things here and correct where he's gone wrong. And it's really a shame that John Paul Stevens doesn't, frankly, know better, considering his long tenure of being a judge, of being on the Supreme Court for many, many years. It's just a shame to see him making such glaring mistakes that even a layperson could catch, which frankly, that is what I am. I'm just a layperson. And if there's somebody, in the comments who does know better than I do, I would gladly want to know where it is I've gone wrong. But this is what I can see just as with my bare minimum knowledge of the court and law and precedents and all of that. So without further ado, let's get started here. District of Columbia versus Heller, which recognized an individual right to possess a firearm under the Constitution, is unquestionably the most incorrect decision that the Supreme Court announced during my tenure on the bench. The text of the Second Amendment unambiguously explains its purpose. Quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." When it was adopted, the country was concerned that the power of Congress to disarm the state militias and create a national standing army posed an intolerable threat to the sovereignty of the several states. So that is in fact true. The Second Amendment was founded to preserve state militias, and the country was afraid that the federal government was going to create a standing national army and pose a threat to the sovereignty of free states. This is all true. I'm glad that we, have a good basis to start off with the truth here. However, the next thing he says here: throughout most of American history, there was no federal objection to laws regulating the civilian use of firearms. When I joined the Supreme Court in 1975, both state and federal judges accepted the court's unanimous decision in United States v. Miller as having established the Second Amendment's protection of the right to bear arms was only possessed by members of the militia and applied only to weapons used by the militia. In that case, the court upheld the indictment of a man who possessed a short-barreled shotgun, writing, "In the absence of any evidence that the possession or use of a shotgun having a barrel less than 18 inches in length has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say the Second Amendment guarantees the right to keep and bear such an instrument." This is not actually true. United States v. Miller did not take issue, in fact, with who was allowed to keep and bear arms, but rather which weapons were allowed to be regulated by Congress. They decided that only weapons that were within the common use of a well-regulated militia would be protected from regulation by Congress. In fact, this was discussed by the majority opinion of District of Columbia versus Heller in 2008. Scalia actually mentioned that the holding of Miller actually does suggest an individual right and not the collective right that Stevens is holding here, based off of if it was a collective right, why would they even examine the type of weapon in the first place? The plaintiffs in Miller were not militia members. They, in fact, were gang members. So if that were to be the reason why it was not protected, why would they even look at the type of weapon used? And rather than just say, nope, not protected, you're not militia members. You even mentioned later on in your article that Miller was in fact about the weapon and not the gunman. So it makes me kind of wonder whether this is, intellectual trickery or just that maybe you just hold, I don't know. But it doesn't make a whole lot of sense to me that you acknowledge both the fact that it was about the weapon and yet here you say it has something to do with that it's only applying to members of the militia. And in fact, I would take issue with your using United States versus Miller as the be-all and end-all of Second Amendment jurisprudence in the first place, given how dodgy of a case United States versus Miller actually is in the first place. The district court judge was actually very much in favor of the NFA, and the only reason he ruled in favor of the plaintiffs was that they knew that Miller, the plaintiff, was a former bank robber who had just ratted on all of his gang in order for immunity, and he would be forced into hiding once the district court case was over. He would not be able to go to Washington and argue before the Supreme Court. The judge, Hartzell Ragon, just wanted to make a binding precedent. And he ended up doing so. The Supreme Court heard the case ex parte, meaning they only heard one side of the story without the other side being there. In this case, that was the government they heard from. And they made their decision based on the case the government presented. So the fact that we're even using Miller as binding precedent to me is kind of disgusting in the first place. But the fact of the matter remains, you didn't even get the holding right. So it's not exactly, firm foundations for your commentary thus far. Colonial history contains many examples of firearm regulations in urban areas that imposed obstacles to their use for protection of the home. Boston, Philadelphia, and New York, the 3 largest cities in America at that time, all imposed restrictions on the firing of guns in the city limits. Boston enacted a law in 1746 prohibiting the discharge of any gun or pistol that was later revived in 1778. Philadelphia prohibited firing a gun or setting off fireworks without a governor's special license, and New York banned the firing of guns for 3 days surrounding New Year's Day. Those and other cities also regulated the storage of gunpowder. Boston's gunpowder law imposed a 10-pound fine on any person who took any loaded firearm into any dwelling house or barn within the town. Most, if not all, of those regulations would violate the Second Amendment as it was construed in the 5-4 decision that Justice Antonin Scalia announced in Heller on June 26, 2008. So in this section, you start discussing, various gun control regulations from the colonial era, colonial Boston, colonial Philadelphia, colonial New York, etc. Why are you even talking about this? All of these laws predate not only the Second Amendment, but the Constitution itself. In fact, most of them predate the Articles of Confederation. Of course they don't line up with Scalia's opinion in Heller. They were never meant to. There was no Second Amendment for them to be held to. So why, I'm not even entirely sure why you're bringing up constitutional violations that predate the Constitution. Until Heller, the invalidity of the Second Amendment-based objections to firearms regulations had been uncontroversial. The first 2 federal laws directly restricting the civilian use and possession of firearms, the 1927 Act prohibiting mail delivery of handguns and the 1934 Act prohibiting the possession of sawed-off shotguns and machine guns, were enacted over minor Second Amendment objections that were dismissed by the vast majority of legislators participating in the debates. So what? Just because they were passed over objections from the Second Amendment does not make it okay that they were passed over that. It just sounds to me like the Congress in 1934 and 1927 just didn't care about the constitutionality of the issue and, perhaps knew that the courts were going to rule in their favor given that it's, the Franklin Roosevelt era and all that he did to stack the courts into his favor. So I don't totally understand why you think that helps your case at all. After reviewing many of the same sources that are discussed at greater length by Scalia in his majority opinion in Heller, the Miller Court unanimously concluded that the Second Amendment did not apply to the possession of a firearm that did not have, quote, some relationship to the preservation or efficiency of a well-regulated militia, end quote. And in 1980, in a footnote to an opinion upholding a conviction for a receipt of a firearm, the court effectively affirmed Miller, writing, quote, the Second Amendment guarantees no right to keep and bear a firearm that does not have, quote, some reasonable relationship to the preservation or efficiency of a well-regulated militia. Again, this is what I was talking about by type of weapon versus the gunman. It doesn't say anywhere that you have to be a member of a well-regulated militia. It says that the firearm has to have some relationship to the preservation of a well-regulated militia. This is also not applicable to Heller versus DC at all, because the weapon in question in Heller were handguns, which in fact would fall under Miller guidelines of common use and relationship to the preservation of a well-regulated militia. Armies the world over and militias the world over all carry handguns. So I don't even know why you're bringing this up again. In fact, United States versus Miller did this entirely within its own case. The weapons banned by the NFA that was upheld by Miller would be protected under military use. If, for example, short-barreled rifles, machine guns, shotguns, short-barreled shotguns, these were all being used by militaries at this point for decades. But by now, by the time Miller would have happened, it would have been for centuries. So, of course, then they probably would have known that, of course, if Miller hadn't been argued ex parte. But, again, this is why Miller should not be used as the be-all and end-all of Second Amendment jurisprudence. It gets its own case wrong. So well settled was the issue that, speaking on the PBS NewsHour in 1991, the retired Chief Justice Warren Burger described the National Rifle Association's lobbying in support of an expansive interpretation of the Second Amendment in these terms. Quote, One of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I have ever seen in my lifetime. Even if the lobbyists who oppose gun control regulation actually do endorse the dubious proposition that the Second Amendment was intended to limit federal power to regulate the civilian use of handguns, that Berger incorrectly accused them of fraud, I find it incredible that policymakers in a democratic society have failed to impose more effective regulations on the ownership and use of firearms than they have. I'm sorry, but why do I care about this? Why does it matter? Why would it matter what one justice, what Chief Justice Warren Berger has to say on the issue outside of court, outside of argument, outside of anything involving the court, just on some random news talk show in 1991? Why would that have any bearing on the issue when the majority opinion actually took out at some time to, listen to oral arguments, research the issue, write up the actual case? Like, I'm sorry, but I think that the evidence in the majority opinion means a lot more than just what Warren Berger had to say in 1991. Like, it doesn't help your case at all to bring this up. And even if there were some merit to the legal arguments advanced in the Heller case, Justice Stevens, with all due respect, I don't think you're the one to be talking here about who has merit to their legal arguments, considering that the majority opinion in Heller actually seemed to have read United States versus Miller. All could foresee the negative consequences of the decision, which should have provided my colleagues with the justification needed to apply stare decisis to Miller. At a minimum, it should have given them greater pause before announcing such a radical change of the law that would greatly tie the hands of the state and national lawmakers endeavoring to find solutions to the gun problem in America. Their twin failure, first, the misreading of the intended meaning of the Second Amendment, and second, the failure to respect settled precedent, represents the worst self-inflicted wound in the court's history. So one, Heller actually did apply stare decisis to Miller in the majority opinion. But two, that's not what judges do. That's what politicians do. Your sole concern should be the facts of the case, the written law and the original meanings behind the law. If the law has consequences that are bad, you bring that up with Congress. It is not a justice's job to consider public policy or the human effect of their laws. No, you uphold the law. That's how it works. That's what justices do. So I'm actually going to skip ahead across the rest of this article because he just keeps repeating the same points he's already made. Talks about like the history of the case and things like that, which are not relevant to the discussion we're having here. So I'm going to skip ahead, but there is something else he says here at the last paragraph where he says, I have written in other contexts that an amendment to the Constitution to overrule Heller is desperately needed to prevent tragedies such as the massacre of 20 grammar school children at Sandy Hook Elementary School on December 14th, 2012, from ever happening again. And I think that is perhaps the stupidest thing I have ever read, or at least one of them. Like, that's just, no. Outlawing guns, the entire point of overturning Heller would be or amending the Constitution to overturn Heller would be to be able to ban guns. That would be the point of that. And that would not solve mass shootings, not at all. I mean, just for one example of recent history, Christchurch happened in a country with incredibly stringent gun laws. Even before the shooting, they're a lot more stringent now in New Zealand, where the shooting happened. But shootings continually happen in cities and states with very strong gun laws. They frequently occur in areas that are gun-free zones. In fact, 86% of mass shootings occurred between 2009 and 2016 in a gun-free zone. We have no reason to believe that banning guns outright would prevent mass shootings, and that is the only reason that you would use to overrule Heller or to amend the Constitution to do so. And I know that's what you want because you've written previous articles about it in the past, but it wouldn't help anything. All you'd be doing is depriving citizens of their liberties. And just no. It wouldn't work. There's no point. There's no good reason to do so.